right, welcome back to episode 2 of Triple P, the Parallel Proceedings podcast, where we explore how individuals and entities manage the complicated world of parallel investigations and prosecutions. I'm Kevin Muhlendorf. I'm a former federal prosecutor and SEC enforcement attorney, and most recently I spent nearly a year as the acting inspector general at WMATA, our metro transit system here in the DMV. In my day job, I'm a partner at Wiley Ryan in our white collar and government investigations group and lead our securities enforcement practice. In episode 1, we talked about the basics of what parallel proceedings are, why multiple government agencies are allowed to simultaneously investigate the same behavior, and how that can affect those under investigations. But you really can't understand this situation without trying to understand what the government enforcers are thinking. To that end, today we have a really fantastic guest who has done it all in the world of parallel investigations. Brian Young, who currently serves as director of the Commodity Futures Trading Commission, the CFTC's Whistleblower Office. When we recorded this episode originally, we had such a good time, we were actually going to break it up into 2 episodes. This first one is going to cover Brian's work in the world of parallel civil and criminal investigations. The second episode is going to focus on his current role at the CFTC. Brian, thanks so much for joining us.
Thanks, Kevin. Great to be here. Good to see you again.
Yeah, it's great to catch up like this, Brian. So Brian currently serves as the director of the Whistleblower Office at the CFTC, the Commodity Futures Trading Commission. And boy, have you guys been busy with new whistleblower awards. I think you put out 4 in one day this week. That's right.
Yes, last week we had 4 awards go out in the same day, which is the most for any single day. But I think probably more importantly, for any fiscal year we've ever had, we've had more award adjudications giving an award than any prior fiscal year.
I love it. Brian Young making it rain for whistleblowers. That's really great. We're going to talk more about that in detail and your work at the CFTC and the great whistleblower program you've been building out in part 2 of this podcast. But first, I think, just to give listeners a flavor of your tremendous background, because I really think that's going to help set the stage for today's discussion, I want to just read off what your resume looks like. It's really one of the more impressive resumes that I know from the federal government, certainly from the prosecution side. So, Brian, you clerked at the Sixth Circuit, is that right?
That's right. I was a law clerk out of law school for a year with the Honorable Alice Batchelder on the U.S. Court of Appeals for the Sixth Circuit.
Yeah, and so from there you went to DOJ, and I just want to pause for a second there and talk about your path to DOJ, because I teach at Georgetown and I've advised a lot of law students on how to get into the federal government. So I think your background there is kind of interesting, the path you took, if you don't mind walking us through that.
Yeah, sure. When I was in law school, after my second summer, I was an intern at the Organized Crime and Racketeering Squad here in the Criminal Division in Washington, D.C. So that was my first exposure working for the Department of Justice. Graduated from law school, and I did the Sixth Circuit clerkship. Back then, I think in the fall, maybe October, November, what's called the Attorney General Honors Program application process opened up. And that's the entry-level application process for getting into DOJ. So I applied to that. I interviewed at several different DOJ components, and I received an offer at the civil fraud section, which is part of the commercial litigation branch. So I was there's not a whole lot of people that go directly from a clerkship or law school into DOJ, but the way to do it is through this honors program, which is an awesome program.
Yeah, and some of the best attorneys I've worked with at certainly at the fraud section came through the honors program. And, it's one of the things I tell some of my law students at Georgetown is there are opportunities out there. There are a lot of opportunities at other federal government agencies too. You really need to take a look at USA Jobs, look for law clerks positions. Another thing that I think Brian mentioned, just free advice to anyone out there looking for a job when you're in law school, is intern at agencies. Show your interest in the federal government. I know when Brian and I were at the fraud section, which we're going to talk about in a little bit, we saw lots of resumes, and the ones that really showed an interest in being in federal public service were the ones that got the second look. And so I think that really makes a difference. I don't know, Brian, do you feel the same way?
I agree with that. And I think doing that internship was confirmation for me. I really want to be here. I'm having a good time and I want to do this. And I think, having reviewed resumes on the other side while working at DOJ, if I see somebody that I know or I think is going to be happy in the job, I'm more likely to hire them. And so that internship I thought was a nice trial run. And then you can also, if you do a good job, you can get references from people at the agency that you're trying to apply to.
All right, so you get this job at the civil division in the commercial litigation branch, and I assume that some of the work you were doing involved the False Claims Act and involved whistleblowers there?
Yes. The civil fraud section is responsible for civil enforcement actions against people or companies who they think are defrauding the federal government. I don't remember exactly what percentage of my matters involve qui tam whistleblowers or relators, but it was a large portion. A large portion of the docket in that office comes from whistleblowers. So that was my first, I guess, exposure to whistleblower practice.
Well, we're going to cover a little bit more detail, kind of how your program's unfolding and all the great work you're doing there towards the end of the podcast. So you leave the civil division and you head to the fraud section where you and I met at the criminal division. We were both the trial attorneys and then assistant chiefs at the fraud section. Then you went on to become a deputy chief. And I think, we're going to talk in some detail about your time there on actual parallel proceedings, because I think that's where this podcast focuses is that space. But let's see. So then you left the fraud section where you were, I guess, as deputy chief of litigation. Was that when you left?
Yes, I was the deputy chief for litigation.
Okay. And then you went over to a really interesting job. You were over at the antitrust division. Just a few seconds on that.
Sure. Well, I was still working at the fraud section, but I took a detail to the antitrust division. And in that role, I started as basically the person who was in charge of criminal litigation. I was a supervisor for all criminal litigation. And they would call it the director of criminal litigation. That involved overseeing, bid rigging, market allocation, criminal cases. Then when Jonathan Cantor was confirmed as the Assistant Attorney General for Antitrust, we modified that role and I took on more responsibilities for civil cases. So I became the Director of Litigation, which included both the civil and criminal portfolios. So civil antitrust cases typically that I dealt with were merger challenges and conduct cases where the antitrust division is alleging anti-competitive conduct.
Okay. That's really interesting. So when did you leave antitrust and come over to the CFTC?
It was February of this year.
Oh, wow. So this is brand new. This is
pretty new. Yeah,
that's great. Well, congratulations.
Thank you.
So just to go back a little bit to your time at the civil division, but then also you probably ran into this in some of your work at the criminal division, the fraud section. I just came back from a really interesting panel that the Council on Inspector Generals put on, SIGI. And there were 3 prominent IGs were there, and they talked about the work they do and how they approach audits versus investigations and how things can move from administrative to civil to criminal. Obviously, a lot of work you do in the False Claims Act space involves IG investigations. In your experience on the civil side of DOJ, how did your investigations interact with the criminal side, but also with the administrative side on things like suspension and debarment?
Sure. I think when I was doing civil fraud cases, civil enforcement actions, we would occasionally refer a case for criminal prosecution. And that generally happened when we saw some documents that looked extraordinarily compelling. You would literally call up somebody at the criminal division and say, here's a matter. I think you should take a look at this. And that's how those cases would move forward. Criminal enforcers will oftentimes review qui tam filings on their own accord and sometimes just make a decision based on the 4 corners of the complaint, whether they want to investigate it. But whenever there was a criminal matter out there and I was doing a civil parallel matter, we thought of it as a parallel case. We did not think of it as a joint case. We would share information, we would coordinate in some respects, but ultimately the criminal enforcers were doing their own thing. And we had constraints about grand jury material. If you're a civil enforcer, you cannot see the government's grand jury material. And by the same token, there's a line of cases that prohibits a criminal enforcer from deputizing a civil regulator or civil enforcer to do some investigative steps.
Yeah, and that's actually one of the things we talk about a lot in our class at Georgetown on parallel proceedings is, can a DOJ attorney tell an SEC attorney to do something? Can they tell them not to do something? It's sort of an interesting question because when you get into undercover operations, there are times where you don't want the civil regulator to be reaching out because of something you're doing. And it seems like that's okay in some instances to tell the civil regulator, don't talk to that witness. We've got something going on. But you can't ask them to ask a question sort of to hide in the tall grass. Is that?
Yes, that's right. I mean, I would want to avoid, I always tried to avoid and think I did avoid doing something, taking some action at the behest of the criminal enforcer. And I didn't want to deceive any party or any witness to an investigation about whether there was a criminal case out there. I may not have offered that affirmatively, but I also, we would take pains not to suggest otherwise. There are ways to facilitate cooperation between a civil and a criminal enforcer. And In particular, rather than using a grand jury subpoena, which can only stay with the criminal folks, you can use an inspector general subpoena. That's a way to obtain documents, and those documents can be shared with everybody. And you can also create efficiencies there where you can have a IG subpoena and there's one subpoena that goes to the company. And then they don't have to make dueling productions, different scopes of production to the criminal and civil enforcers. And sometimes you asked about administrative enforcers, for example, a suspension debarment official. I did have some contact when I was in civil practice with suspension debarment officials, but generally speaking, it was much more distant than any contact, any cooperation you have with criminal enforcers. There is a sensibility and in fact a directive where civil enforcers in the Justice Department are not going to threaten or try to leverage a suspension or debarment consequence to help their own civil case. And because of that directive, there was very much a sensibility of we at the civil division do not get involved in suspension debarment decisions. Maybe you provide information, but there's really a sensitivity to try to being perceived as trying to influence a suspension decision.
Yeah, that's really good information. And I'm sure our listeners will appreciate that because, if you read the guidance that SDOs get, it talks about suspension debarment is about present responsibility. It's not about punishment and things like that. So anyways, that's good. You reminded me of a thing we sort of always remind our clients. So on the defense side, one of the things that we run into is we often get an STC subpoena, a CFTC subpoena. And, it comes with a warning that says this could be turned over to the criminal folks. And that's where this parallel proceedings and sort of the whole point of this podcast, that's the sort of art to this, is figuring out, is there a criminal investigation behind it? And oftentimes you just have to assume that there is, even though if it's not the case. And as representing clients and deciding whether they're going to testify, deciding whether they're going to do a proffer, that's one of the things we really struggle to figure out is how much can we give the civil authorities? Is it worth taking? Do you just take 5 for individuals and risk the adverse inference, knowing that the criminal folks might be out there? And it's a tough decision, especially for individuals. All right. So flipping back now to the fraud section. You spent the most time in crime. We did about 10 years, I think.
Probably 12 years.
Oh, 12 years. Wow. Okay. Yeah. So, and we had, look, it was a great time to be there. We had some great cases. In particular, you had some really interesting cases that I want to let our listeners know about because they really do hit to the core of this parallel proceedings issue with the CFTC and with the SEC. So tell me about some of these cases. Let's start with cases involving individuals. And I threw out the word CFTC and SEC, but were there other regulators you were working with in some of these bigger criminal matters you had at the fraud section?
Sure. Occasionally the Federal Reserve. A number of cases would involve foreign regulators, the FCA, BaFin, places like that.
And that's for people who don't know, the FCA is?
It's the securities regulator, securities and derivatives regulator for the United Kingdom.
And BaFin?
Same for Germany.
Yeah. Okay. So working with foreign regulators, and that's a different, I think a lot of people, especially people who do this, domestically, you think, okay, well, you've got your SEC, your CFTC, maybe you've got an IG's office. But in a lot of these cases, especially with companies now being global and enforcement being global, we have seen a tremendous increase in cooperation among foreign regulators. And so is that something you saw when you were there, that foreign regulators took a bigger interest in the cases we were doing in the fraud section?
I think by virtue of the types of cases that the fraud section did, foreign regulators were involved because a lot of our cases involve the financial markets and they involve people all over the place in London, New York, the Netherlands. And so just the facts that we were investigating necessarily implicated regulators from all over the world.
All right. So I want to talk about one of those cases you had worked on. One involves something called LIBOR, which I guess really doesn't exist anymore. I know it's going to be hard in a short podcast like this to give a 1-minute description of what the LIBOR case was about, but if you can try, it would be helpful.
LIBOR was a benchmark interest rate, and it was a number, and that number influenced the profitability of bankers' derivative positions. If I had to dumb it down or simplify as much as I could, I would say that the Justice Department alleged that bankers who had a role in setting that number manipulated that number to gain advantage over their counterparties to derivative contracts.
Okay. So putting us in the context of parallel proceedings, I guess a couple questions that I wanted to explore. One, In the instances where you were working with foreign regulators, were there pitfalls that the government ran into that you can talk about, obviously, that are make it harder? I look at it from the angle of how is it harder for a defendant, but these parallel proceedings have their pitfalls for the government too, right?
Sure. I don't think I don't want to address any particular case, but I can speak in generalities about what is difficult or what the hurdles are to having a parallel investigation with a foreign regulator, especially in a criminal case. I was always concerned about if I'm going to share information that a cooperating witness gave me, and I obtain that information from that witness under proffer protection, that is, I made an agreement to have limited uses. I can only use this information for certain purposes. If I was going to turn that information over to a foreign regulator, I wanted to be sure that foreign regulator would be able to honor those promises and those representations that I gave to that witness. And you could see a situation where maybe the foreign regulator says, I can't abide by that promise because I have certain discovery obligations, or I didn't understand the promise. So that was I remember thinking a lot about those issues. There can always be data privacy issues where somebody wants to give you information, a bank, an individual wants to provide you with information, but they interpret laws in the country in which they operate is restraining that. There can be issues, and there was a Second Circuit decision reversing a matter on what's called a castigar concern, and that is whether or not a government enforcer uses compelled testimony against a criminal defendant. And that can be implicated in a foreign context, because if a court determines that a conversation that a foreign regulator had with a criminal defendant in the United States, if they determine that conversation was involuntary or compelled, then that information should not be used as part of a criminal case in the United States. And so you have to do your best to understand what is the process through which a foreign regulator is getting this information, and could it implicate a defendant's Fifth Amendment rights in the United States?
So I guess, do you think, and I'm asking as a defense lawyer, so you may look at it differently, does the specter of a criminal investigation, you think, affect in what you saw how people respond to civil requests or civil demands for information?
It could.
Yeah.
It certainly could. I remember doing civil cases where somebody would take the Fifth. They think that there's a criminal case out there, and they just decline to answer the question. And in a civil context, you can make an adverse inference about that. Sometimes a company has a little bit more difficulty doing that because they don't have a Fifth Amendment right, and so they're going to have to produce documents. I think sometimes defendants have active production concerns. They may want to produce documents, but they don't want to make admissions about how they received the documents. And also, more generally, I think companies think about, well, if I resolve this criminal matter and admit criminal liability and attach a number to that, then I could be exposed to private civil suits. I could be exposed to suits brought by regulators or state enforcers. And I'm stopped from denying that because I'm admitting to that in public. And that's always an issue that comes up with these parallel matters.
Yeah, no, that's a really good point. And I guess a question I wanted to ask about. So when you were working on these corporate matters at the fraud section and you're doing these resolutions, you've got a bunch of interests at the table. You've got the civil regulator here in the United States. You've got foreign regulators. You've got DOJ. Does someone quarterback that for the government, or is it sort of a free-for-all? I know we have the anti-piling on policy, and we have all these policies that have come out, but is there, I was at a panel recently where someone talked about, usually it's the federal prosecutor that steps in to coordinate that because someone has to be the quarterback. And does that usually happen, or is it incumbent on the company to do it, you think, or who should be running those traps?
I never thought of it as being the quarterback. I sort of thought of it as, I'm here to resolve the criminal case, and I'm going to do what's best for the criminal case, and whatever happens in the other matters happens. I think because I did not want to be appearing to have an influence on the civil case. And so I think if I were a criminal defense lawyer and I wanted to see more coordination, I would try to take that into my own hands and propose a joint meeting because that's a safer position for the prosecutor to be in. If you're responding to a defendant's request, you're less vulnerable to an accusation that you're trying to influence a civil case. I do remember thinking a lot about piling on, which is when you have multiple enforcers imposing fines, do those fines in the aggregate become unfair? Maybe one particular enforcer, you can justify that result, but in the aggregate with foreign, maybe state regulators, does that become unfair? And those issues are not easy to resolve because you have so many people involved. Maybe any given resolution could be perceived as fair in and of itself, but the aggregate effect of that is an issue, and somebody might need to take a haircut.
Yeah, and one of the things you've said a couple times in response to my questions, which I just think it's worth commenting on, is that these issues, you gave a lot of thought to them. And I think that's something people from the outside need to understand, is that, at least at the fraud section, certainly people were really thinking hard about these issues and trying to get it right. But from where I sit now, I mean, the good news about that is, A, it's still happening, I think. But two, it gives you as an advocate a chance to help DOJ get to the right result. And the people are listening, right? I mean, is that fair?
That was my experience. I felt like I tried to listen. Maybe some of my adversaries would dispute that. But I think what really helped me, especially in a corporate context, corporate prosecution, where you're talking about a CMP, civil monetary penalty, restitution, and the form of the agreement, is if somebody came in and said, I have looked at the prior corporate resolutions that DOJ has done in similar contexts, and the most similar cases are the following. And I think that should be the reference point for you to decide how to resolve this case. I thought that was helpful because you want to try to treat similar people similarly. And if there is disagreement amongst various different enforcers from different agencies, somebody can point to a past result as an objective measure to say, well, I know we might disagree, but this is the way a similar case was treated in the past. And unless we have a reason to deviate, I think this really should be our North Star here.
That's great advice. So just looking back at your time at the fraud section, and we'll sort of combine it into the single question of individuals or entities. Was there anything you saw from defense counsel that was just really smart, and you don't have to name the case or whatever, that you just said, wow, that was a really good way to handle this, that really stuck and really advanced, getting to the right result?
Sure. I thought there were a lot of effective things. I, as a prosecutor, had more anxiety for shorter cross-examinations in court and more directed examinations than I did for long multi-day cross-examinations. Now, maybe there's reasons somebody has to do a long multi-day cross-examination, but I can't remember instances where I thought a defense lawyer scored a point, but it was in the middle of a really lengthy examination and the jury probably didn't pick up on it. I felt that I was more nervous when the cross-examination was a quicker tempo, moving from topic to topic quickly, and the jury can appreciate every question that's going on. I've had several instances I'm aware of several instances in which a criminal defendant in the United States who lived in a foreign country waived extradition and came over. They got charged. They had a decision. They could have contested extradition in a foreign country. They waived it and came over. And I kind of thought, looking back on it, that was probably a pretty good decision, because if you resist extradition in a foreign country and the Justice Department prevails and you get extradited, they have a reasonable argument that the client should be detained when they get to the United States. And it could be a while before the trial happens, right? And the defendant is detained in those circumstances. If they waive extradition, it's much more likely that the defendant is going to get bond and is going to be able to go back to where they reside to live there during the pendency of the trial. And I understand that a criminal defendant who lives in another country, they have to make a decision to show up in the United States without a guaranteed bond package. The government can tell you what they're going to recommend, but ultimately it is the judge's determination. And I can see how that could give a defendant some anxiety. But at least in my experience, things never went sideways. I never felt like a defendant's expectations were upset when it came to bond and coming over to the United States.
Well, yeah, I think that's a really good observation. And I think it gets to the heart of kind of what we all do in representing individuals and entities and dealing with the federal government is both trust and cooperation and communication, I should say. I mean, I think as long as expectations are set and communicated and everyone understands what they think is going to happen, it tends to work out on stuff like that. You can't predict what a judge is going to do, obviously, but the ability to have open discussions with your adversaries tends to hopefully at least advance the ball and everyone knows where they stand, which I think is really important. That's just tremendous insight. That's why I'm so glad we were able to bring you to our listeners. As we always do, before we go, I want to touch on a couple of news items from the parallel universe. The first, at the Society of Corporate Compliance and Ethics annual meeting, the PDAG announced revisions to the Department of Justice's program. They have a document out there. I think the fraud section put it out a few years ago, the evaluation of corporate compliance programs. And for those of you who don't know, and you haven't seen this document, reach out to me. We can get you the document, or you could read one of the 1,000 client alerts that went out yesterday about it. But it's sort of a checklist about how the fraud section evaluates your compliance program. And there were some interesting new focuses in there that the PDAG raised. One was on new technology and AI, which I thought was really interesting. But the other one that was what we've just been talking about too is how companies address whistleblowers, how they protect whistleblowers and avoid retaliation. And it also mentioned that another focus was on leveraging data and lessons learned. And then the other news item I just want to point out for everyone is we're in September. This is when the SEC does their fiscal year case dump. If you've been getting the SEC alerts, they've been just rapidly pumping out cases. And I thought one that was particularly notable that came out recently was about off-channel communications. And I know that's been a big issue for your agency, Brian. It's been a big issue for DOJ and certainly for the SEC as well. And one of the things that the two commissioners dissented on was that, and this is a quote from their dissent, was the SEC cannot enforce its way to compliance. And in that particular case, they noted in the dissent that the regulated entity had really tried to comply, but employees, as they sometimes do, found a way around the internal guidance that they had. The two commissioners said that the SEC was trying to equate reasonableness with perfection and implored the agency to sort of engage with compliance professionals to get an idea of how best to do this rather than to just sort of do it through enforcement. I know, Brian, I'm not going to ask you to comment on that because I know that's stuff you guys are, I'm sure, are working on. But, and finally, as always, if listeners out there have any questions, comments, or concerns, let us know. If you send me a question and we answer it in the next episode or one of the next episodes, we'll send you some super cool Triple P swag. Brian, I can't thank you enough for coming on Triple P. This is the #1 podcast on parallel proceedings, and you are our #1 guest so far. So we really appreciate you being here. This has just been a tremendous discussion, and you're just a wealth of knowledge and tremendous experience. My name is Kevin Muhlendorf. You can reach me at KMUHLENDORF@wiley.law or find me on LinkedIn. You can find the Triple P podcast on the Wiley website, on SoundCloud, or wherever you get your favorite podcasts. Thank you again for being here. This was a little bit longer, but I think this episode was well worth it, and we look forward to speaking again.
Happy to help.
Thanks, Brian.